Very good afternoon, everyone. Welcome to this seminar on the Data Protection Act in India. As you know, India is a digital society with potentially 1.4 billion internet users, which means that there is a lot of personal data being collected and processed by businesses, government agencies, and other organizations. The Data Protection Act is a new law. While we were initially formalizing this seminar, it was a bill, but very recently it has received precedent assent and it has become a law which is applicable throughout all of India. As most of us know, it is passed in the Rajya Sabha on 9th of August and in the Lok Sabha on 7th of August. It is expected to come into force in the next few months. The Data Protection Act is relevant for professionals in a number of ways, including giving individuals more control over their personal data. It will make organizations more accountable for how they use personal data, help individuals from identity theft and other cybercrimes. I hope this seminar will help all the audience understand the Data Protection Act better and its relevance as a professional. Now, I would like to call upon our President, Mr. Shivendu Chandar, to deliver his address. And before that, although he does not need an introduction, but due to the formalities, I will still introduce him anyway. So, Shivendu Chandar is a fellow member of Institute of Chartered Accountants of India and associate member of the Institute of Cost and Management Accountants of India. He is also a CISA, GISA, ICCP, and FAFD. He is a past chairman of the Institute of Chartered Accountants of India, the Eastern Region, and past convener of CA ISA Study Circle EIRC. His programming language knowledge includes BASIC, Relay, Oracle, Developer 2000, and other languages, and he has managed several offshore projects for customized software. He has represented ISACA Kolkata chapter in global leadership conferences like Toronto, Canada, Lisbon, Portugal, as well as the Asian Leadership Conference at Kyoto, Japan. He is a managing partner of Kildare Khatto and Associates and is a regular speaker in various forums and has contributed several articles to various professional journals and magazines. He has a distinguished academic career and has greatly contributed to the profession of our fraternity. Shwendu sir, I would like to call you for giving your opening remarks.
Thank you, Chirag. Uh, Today's webinar would not have been possible without Chirag. So, special thanks goes to you. Uh, I welcome all of you to today's webinar. And as it has been our endeavor to bring in to all the members and the students of CISA the latest topic of discussion. And today's topic, as Chirag was explaining, is one of the most relevant and talked about topic because of the great importance that is associated with it. Today, each one of us are facing problems of our personal data having to be inserted into various databases, not only the government databases, but also uh, various companies are using our data and storing this data. How much they can store this data, how much they can use, whether they can use it for only the purposes that they are supposed to, or they can share this data with other uh, companies, other government agencies. That is what is the very, very pertinent question that comes into everybody's mind. Now, as you are aware that the law outside India, particularly the more advanced nations, the European nations, US, they have had a lot of regulations for protecting the data of individuals as well as companies. But in India, we have seen in the past that there has been lot of instances of misuse of data. Therefore, I think this topic of today is of great relevance to us, and especially in light with the new regulations which have come in and which will become mandatory in India. I think this calls for a major discussion, and it will be a big value addition to our knowledge of the data privacy law. But just a few moments I would like to deliver on the chapter activities, which most of you as members and associated with the Kolkata chapter of ISACA is aware of. We have been having regular programs on various topics of relevance, as I mentioned. We had one such seminar in the month of March, where we had a detailed discussion on the topic of COVID. And COVID, as you know, is the standard that has been used across the globe, the IS standards, and it has also been adopted to a large extent in India. And we had as our speaker Abdul Rafiq, who had discussed at length on this topic. Subsequently, in the month of April, we had also another very interesting session on forensics by the first principles, and it was taken by Lieutenant Colonel Snehamoy Banerjee, who was also a very prolific speaker, and there was a lot of good reviews from the audiences regarding this seminar. So, in keeping with that momentum of having a very, very good webinar, I'm sure that today's webinar will also be good. Apart from having very good webinars, we have also been successful in organizing the CISA review classes. And this time we had quite a lot of students' participation in these classes. We had held online classes this time, and a special thanks goes to Mr. Sandeep Ganguly, who had very well organized these classes, and there has been very good reviews from the students about our classes. We also had regular board meetings, and there has been lot of interactions in the board meetings, and uh, all the board members, they have contributed to keeping this ISACA Kolkata chapter vibrant, and we would look forward to more and more participation as we go along for the rest of the year. And I promise that there will be many more interesting uh, webinars. We will have physical seminars also. That is also in the card, and there will be lots and lots of things to uh, have our intellectual minds to be fulfilled. So, with this small introduction, I hand over the proceedings back to Chirag, so that without further delay, we can start the proceedings of today's webinar. Thank you so much.
Thank you, Shivendra sir, for your kind words. Dear members, it is my honor to introduce our keynote speaker for today, Ms. Vasundhara Shanker. Ms. Vasundhara is a prominent face in the legal industry with a reputation for providing innovative and effective legal solutions for over 9 years. She is the founder and managing partner of Verum Legal, a law firm that has helped over 500 startups with their legal requirements. Ms. Shankar is a top-tier lawyer, a legal tech evangelist, and has been named among the top 100 lawyers in the Forbes Legal Powerlist 2023. Her area of expertise includes data privacy laws, technology-related laws and issues, IPR, commercial disputes, corporate transaction laws, dis- dispute resolution, white-collar crimes, including cyber crimes, cybersecurity, etc. It is our honor that Ms. Vasundhara has consented to grace us with her words today. Ms. Shankar, looking forward to an engaging session from you. The floor is yours, ma'am.
Thank you so much for the kind words, Chirag. And I will, first of all, I would like to thank ISACA Kolkata chapter for having me here to discuss an issue which is extremely prevalent and extremely, discussed right now as an issue that doesn't only impact or affect the the legal industry or the technology industry, but also has an impact on each and every individual and citizen of India. In today's session, I'm going to try and discuss the new Data Privacy Act. I'm very happy to call this an act and not a bill anymore after, because it has been years of waiting and a lot of patient in anticipation of this act that we finally have in place. So we'll be discussing the act in detail, and then we'll also be discussing some everyday issues that people face, that we face as individuals, as people who are data subjects, but also data processors, and people who are also processing and storing data in various ways. So just to start off with, I would like to um, talk about what is data, and what does the Indian Data Privacy Act talk about. So back in 2017, privacy was declared as a fundamental right by the Apex Court of India, the Supreme Court of India. And since then, the government of India has made continuous efforts to safeguard and protect the fundamental right of privacy that each of its citizens have. As all of us know, that digital space is one such area where the privacy of people is extremely is at a very high risk. Personal data, personal information, which is also known as personal information colloquially and in other parts of the world, has been something that has been declared to have the potential of being the biggest asset going forward in this technology world. So it becomes very important to have a framework that regulates the use of data, the way this data is dealt with, stored, shared, and collected, most importantly. Countries across the globe have had several legislations to protect the citizens' privacy in the digital space, and we may be aware of Europe's GDPR, California's CCPA, even which is the Consumer Privacy Act. There is Brazil's General Data Protection Law, and many more. India has been, like I said, in the drafting phase and the discussion phase of the Digital Privacy Act for the past 5-6 years, and finally in 2023, the act was passed, and it was called the Digital Personal Data Protection Act 2023. Now, as you can see, the name itself, it's not a simple data protection act, it's not a simple personal data protection act, but it has keywords such as digital personal data protection. So, as the name suggests, it looks at all of these components. It looks at the digital world, it looks at personal data, and it looks at protecting that personal data, right? So we will move on to discussing what does the Digital Personal Data Protection Act deal with. I'm not sure how many of you have actually gone through the text of the act, but it is a fairly short but comprehensive piece of legislature. And as lawyers, we generally like it when laws are brief but also all encompassing. So it's always because it's lengthy laws are difficult to kind of remember, execute, and also understand in its all its comprehensibility. So this is a great piece of legislation, I would say, from that angle. Whether it is what is the need of the hour, whether it is developed enough, whether it is advanced enough, whether it is all encompassing enough or not, we will hopefully learn a little bit more about that during the course of this session. So, if you see, every piece of law in India has its objective. Why is this law important, and why did it come into picture? So, the Digital Personal Data Protection Act, the objective of this act very clearly states that it was to recognize the right of individuals to protect their personal data. So, very clear with its objective, very clear with what the Digital Personal Data Protection Act, or the DPDPA, as it's also being called, is meant for, to recognize that individuals have the right to protect their personal data, right? And the act also recognizes that there is a need to have personal to have very only collect these personal data for lawful purposes. You cannot collect someone's data for any purpose which is not lawful, not legitimate. Like, you can't coerce or threaten someone to collect their data, would be one way. Or you can't put a condition in an unlawful manner, in a threatening manner, and try and collect their personal data. So that is very, very clearly, very, very succinctly described in the very beginning of the act that we are going to deal with. Now, very quickly moving on to some terms, I will be discussing some terms that have been defined in the act in order to explain what is different and what actually the act has been talking about. So, I mean, I am, of course, someone who has been dealing in this domain since, I think, for the past 5-6 years, especially since the GDPR came into the picture. Lots of Indian companies were falling in the ambit of having to comply with GDPR, owing to the fact that they were dealing with data, personal information that belonged to European Union citizens, or residents of the European Union who were maybe moving around in the world. So lots of people came up to us and asked us for to help them with complying with the GDPR. Now, when we look at the GDPR, because the I honestly believe the GDPR is the setting stone of data privacy laws as far as legislations are concerned, because it is one of the most comprehensive laws. It is a very democratic and equitable law in that manner, in that sense, and it is also very. It was kind of a game changer in the in the data privacy domain. So, as all of us know, the biggest importance, or I'm not sure if all of us know, but the biggest importance that was given in the data privacy GDPR laws was to consent, which basically what that did was that it gave the maximum amount of power and authority to a user, at least on in text, at least on paper. Every person who's collecting my data needs to take my consent. Now, whether that consent is explicit was also defined. That consent needs to be explicit. Just because I'm on a platform, just because I'm using your website or your app, doesn't mean I'm giving my consent to you to be able to use my data. So that I have to give you an express consent, and that was very, very firmly and clearly established. So like that, there are lots of different terms in the in our privacy protection act today that we are going to be discussing, the DPDPA. So the first term that we'll be discussing is data. Now, what does the act define data as? It simply says that data is a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing by human or automated means. So, you see, one other very, very important point that we'll notice throughout this discussion is that this act is very, very digital and technologically advanced in nature. It keeps talking about automated automation, automated means, machines, technology. It also has a definition of digital office, which I found very interesting. Because we have a concept of digital office colloquially. We have the concept of virtual office and work from home and digital office, etc. But it has so far not been defined anywhere in any legislation. So this legislation is perhaps one of the first legislations in India which defines digital office. Maybe in a different context, I agree and understand that, but still, I would say this is a great start. So it defines a digital office as office that adopts an online mechanism, an office which has where you can approach, and everything is online. You can file a complaint online, you can the procedure happens online, you can be heard online, and then your solution is also given to you online. So that is what a digital office is. The third term that this act defines, which really struck to me, and I found it to be very useful and interesting, was automated. What is automated? Automated, it means digital process which is capable of operating automatically in response to instructions given for processing data. So again, you see a lot of automation and machine responses, machine activity is being mentioned here. So I would say that this act does encompass the possibility that there may be people, there may be entities, very large organizations that are dealing with data which is through an automated system. Maybe like for example, these days we have Zomato. Everybody uses Zomato. When you go, when your order is delayed, or you get the wrong order, you ordered a bowl of soup, and you get a plate of paneer chili. In that case, when you go and try and chat with Zomato, it takes a very long time for you to be able to connect to a person, because you're interacting with their automated bot. But even that automated bot, like the way this bill has been drafted, this act has been created, even that automated bot, whatever data it collects today, falls under the ambit of collection of data through the Zomato platform. So it doesn't always or necessarily have to be any collection of data that is happening only through an individual. It can also happen through automated platforms. We all know, I mean, everywhere you go, e-commerce websites, most of these platforms are all dealing with automated customer care services now. We are mostly talking with bots, right? Only after a very long conversation, them not being able to help us, is when we get transferred onto a human being that we can speak to. So it's a very progressive step in that direction, that automated, the word automated has been defined again, perhaps the first time in an Indian law. Now, what the data DPDPA goes on to do is it also defines certain personals or parties that we'll be dealing with in this entire legislation and today's discussion. And when it does that, it basically talks about who are, we've all heard of, if you are familiar with data privacy laws, we've heard of data processors, we've heard of the word data uh, DPO, which is a data protection officer. But this law goes on to define something called the data fiduciary. Now, who's a data fiduciary? A data fiduciary is any person. Okay, now it does not only define entity, but it also says person. And it goes on to specifically say person, in fact. It says any person who determines the purpose and means of processing personal data is a data fiduciary, right? So it can be anybody sitting in an organization also who is determining the purpose and means of processing the data that they are collecting, the personal data that they're collecting, and that would be a data fiduciary. Who is a data principal? Now, the second terminology here is data principal. I think this is a similar term to data subject, which is how GDPR defines it and mentions it. Data principal is an individual to whom personal data relates to. So it can be you, it can be me, it can be any of us. Whoever's data is being stored, is being collected, is what a data principal is. It also, now again, this law goes on to actually acknowledge, accept, and cater to children as well as disabled person. Children, much like the GDPR also does. It also includes a very detailed section, which we'll be discussing later on how companies dealing with children should be collecting data. So, like, as an organization, again, we work with a lot of edutech companies which are for kids going into school from grade 1 to grade 12, who are all under the age of 18 years. Then there are also edutech companies which are pre-nursery. There are nursery edutech. There are lots of edutech companies these days, especially with post-COVID scenario where everybody has become very familiar with education happening on the internet, education happening through videos or through platforms and apps, etc. So it becomes very difficult for an edutech company to be able to create a very holistic privacy policy, for example, when they are being onboarded onto the platform, onto Google Play Store or an Apple App Store. Which is why this law in picture really helps, because we are clearly defining that when there is a child, their parent or legal guardian is what are the people that are going to be able to are the ones who have to give the consent, the lawful consent that we need. Cannot be from a child, it has to be from a parent or a legal guardian. And same for a disabled person, that it has to be given through a lawful guardian and not through a person who is unable to kind of consent or make the decision of consent in such a scenario. The third term is data processor. So any person who processes personal data on behalf of the fiduciary is a data processor. So now, for example, we have a data fiduciary who can also be another person, and the actual person who does the processing of the data, the actual person who is collecting the data, deciding where it gets stored, deciding where it gets, how it gets stored, whether it's pseudonymized, whether it's aggregated, whether it's being stored as is, as personal data. That person is going to be called as a data processor. So that is that. I'm hoping that I'm not getting too technical, because I feel like it's important to define these things, because the act is so new. A lot of us may not know what all it entails, and I find these things very interesting because we've been waiting for this act. Like I said before, that's one thing, and the second is that there are lots of different aspects to this law which makes it extremely interesting. For example, one aspect that I may not have covered in this presentation today is that it defines her separately, like her, like a female. Then it goes on to talk about in definitions when it's defining these personals. It goes on to talk about the personal in the female tonality, so it uses her instead of him, which is again a change, welcome or not, but it's definitely something that's new. So I found that extremely interesting as well when I went through the act. Some more personals that the Act has defined: significant data fiduciary. We now know what fiduciary means, what data fiduciary means. This is significant data fiduciary. Any data fiduciary or class of data fiduciaries as defined by the central government. Another point that I would like to make here is that this act does have, has gone ahead to leave a lot of powers or decisions or announcements in the hands of the central government through notifications, through gazettes. There are lots of aspects to it, which was the case even in the previous act. I think they have still toned down a little bit with respect to that in this final act. But yeah, there are still a lot of aspects which are left in the hands of the very able central government that we have. So significant data fiduciary is essentially data fiduciary, but appointed or notified by the central government. So that will happen, and as and when the years progress, where the central government decides to announce or nominate someone as a data fiduciary, that they'll be called the SDF. Um, Again, this is the second one is data protection officer. That is again a concept that exists even in the GDPR, albeit a little different. The definition is a little different, but it does exist in under that law as well. It is basically any individual that is appointed by the significant data fiduciary. Now, so you see the flow: the government, the central government will appoint the significant data fiduciary, and then the significant data fiduciary will appoint a data protection officer, right? So that's essentially how it flows. Then there is another interesting aspect, which is the consent manager. They have introduced which is not a part of GDPR or other existing laws, which is called the consent manager. It is a person which will be registered by the board. We will be discussing what this board means and what it entails. And this consent manager, interestingly, will be a point of contact to enable the data principal, which is the data subject, which is you and me, to give, manage, review, and withdraw consent. So very similar to a grievance officer, essentially, right? Like we all of us understand the concept of grievance officer. Consent manager is similar. Basically, it's a very good play of words as well, that this person is going to essentially manage my consent. So whether I want to remove it, whether I want to withdraw my consent, have erase my data, or give manage my data, update it, all of that, I have to connect with the consent manager, perhaps. Again, very interestingly, we'll see that the act defines person in many ways. It talks about person as being an individual. It talks about person as being an HUF, which is a Hindu undivided family, company, a firm, association, the state, of course, and any artificial juristic person. So a very broad definition to the word person, and essentially anybody who can be considered to be a legal entity. Personal data. Now, again, we saw what data meant. Now we'll see what personal data means. So, any data about an individual who's identifiable by or in relation to such data. Again, another aspect is this act has now gone ahead to remove the concept of sensitive personal information or sensitive personal data, which exists in other laws, and deals with data which are more considered to be more sensitive, like your financial information or your health information or your sexual orientation, etc. So personal data is the only term that is defined as far as data is concerned, data and personal data, and it does not categorize or define anything specific to that data. It just goes on to say that any data that is about an individual who's identifiable by, so if that data is able to identify that it's about me, Vasundhara, then that is a personal data, and that's it ends there. There is no gratification, there is no classification, there is no complication, to say the least, like, to be honest, right? So that is, again, I think a pretty fair way approach of defining these terms. Now, coming down to the second most important, I said the first most important aspect was consent. The second most important aspect is the purpose of that consent. Why are you taking my consent? Do you have a purpose to take my consent to collect my data from me. How is specified purpose defined in this act? Purpose mentioned in the notice, which is a notice which is being sent by the data fiduciary to the data principal, which should be in accordance with the provisions of this act. So whatever purpose it is, that purpose has to be in accordance with the act and not in uh, you know uh, not something that is essentially unlawful or in contravention to the act. So that is what specified purpose means. Now, I would like to take you towards how has this act defined that how can a person like yourself, like myself, go ahead and file a complaint if I have an issue with my data, the way my data is being processed. It has again been defined pretty fairly, pretty well, and has been given a very good structure, I would say, wherein the first stage of complaint is to the grievance officer or to the consent manager. Basically, what this does is it talks about how the individual can go ahead and connect with the grievance officer, how they can go ahead and speak to the officer and file a complaint. Or maybe even it can be simply to edit my data, alter my data, update my information, erase my the right to be forgotten, as we know it very very commonly and popularly now. So we go to the grievance officer. The grievance officer can listens to us and decides on whether our complaint is genuine enough, is something that they should be considering as a legible complaint, and then takes an action against it. The grievance officer may or may not give us a solution, may give us an order which may or may not feel like a solution to us. If it does not feel like a solution to us, we can go to the data protection board. Now, what is a data protection board? The data protection board, or the DPB, is a very very is a very important and new concept. Actually, it's something which is similar to an ICC under the POSH law, but is going to be set up by the government. Now, the data protection board is basically comprises of multiple members. It comprises of a chairperson, which is going to be heading the data protection board, and then there are several members in that data protection board. One of the members is also the consent manager again. So the data protection board can be approached by an individual after the grievance officer has already given their final take on the matter, and the DPB, or the data protection board, can then decide on further either to uphold that final take, or to go against it. Once that is done, the next option that we have is an appellate tribunal, which is also called the TDSAT, which is basically the tribunal which deals with the telecom laws in the country. So again, a fairly well thought out procedure. Instead of setting up an entirely different department and setting up a new tribunal at this point, the TDSAT is fairly well oiled. It has been dealing with very very grave and massive issues of technology, of communication, media related issues. And the TDSAT tribunal members are also very very well educated, highly efficient, and qualified to handle perhaps privacy issues as well. Only time will tell, I guess, because we are not really on how, whether we do need to have a specific set of people who can understand data and privacy and technology better, or the TDCAT members are good enough to do so. So that was about the aspect of how can you complain in the under the data privacy laws. Now, what are the grounds for processing data? Now we go on to, can anybody process data? What do I need to do to process data? Can I do I just need to start taking consent from people? Do I need to have actual grounds for it? Again, very similar to the data privacy law, the GDPR as well. The Our DPDPA goes on to state that any process the person any person who wishes to process the personal data of a data principal shall only do so in accordance with the provisions of this act and for a lawful purpose. Now, you see the word in compliance or in accordance with this act is also used very, very commonly throughout, which is essentially to establish that we consider the act to be extremely important, and is perhaps, since it is the first privacy law that the country has passed, it has to be, it's a non-negotiable. You have to comply with it at all times, and for a lawful purpose. Like I said, lawful purpose again is a very, very important specified purpose. Lawful purpose, very important aspect of collecting data, for which the data principal has given consent for certain legitimate use. For the purpose of this section, the expression lawful purpose means any purpose which is not expressly forbidden by law. Now that again broadens our ambit of what does lawful purpose mean, because you're saying expressly forbidden by law. Now if there is any technology tomorrow that comes in, like generative AI, all of us know about it. Is generative AI even dealt with in any of our legislations? Perhaps not, right? What if tomorrow generative AI comes up with a way to collect my data, which is, or it collects my data for a purpose that is not forbidden by law, for creating my deep fake account, for example, which is, or for creating my avatar, like online avatar, is that forbidden by law? Yes, if you go by extension to see impersonation or misrepresentation, maybe, but not expressly forbidden. So I feel like that maybe could be a possible loophole that lawyers can use and really like churn out of churn, like find ways for their lawyer clients to circumvent, or for companies to circumvent. So we have to see that the law specifically says that the data principal has to give her consent. Like I said, her, right? You see there, this is an exact excerpt from the act itself, and it uses her as yeah. So there has to be an express consent for the purpose that she's given her consent, not no other purpose. I cannot today I give my consent to a company to deliver some, say, just my, like very specific consent. All of us know that it doesn't work like that, but say for example there is this hypothetical situation where I'm giving consent very specifically to Amazon, for instance, to deliver an item to me. Tomorrow they start sending me newsletters. I did not sign a terms and conditions which asked my permission for newsletters as well, right? They have my email address, they have my house address. I did not ask them to send me newsletters. I did not expressly consent for it. I only consented them to give me my item of delivery and update me about it on email. That's it. I didn't expressly ask them to contact me on email otherwise, but they do so, right? So I know this is not a very solid example, because every time you're consenting on use of emails, you're generally also consenting on receiving newsletters and updates and discounts, etc. But just as an example for us to understand. So then if my consent is limited to a purpose, that is the only purpose that that the data processing individual should be considering. And the second is called legitimate use. Again, legitimate use, lawful purposes, defined as any purpose which is not expressly forbidden by law. Yeah, that is very important. Now we come down to consent. The act also goes on to define consent in section 6 of the legislation. Um, Again, consent shall be, it goes on to say, free, specific, informed, unconditional, and unambiguous. Extremely, strong words. Um, these are words that we generally use in our contracts also when we are drafting them. But yeah, that's there. It has to be free, it has to be specifically given for a purpose, it has to be informed. I need to know that I'm giving my consent. So like express consent essentially. It has to be unconditional. Now, do you see, there is specific, then there is unconditional. So I'm giving specific consent to you, but you cannot condition it. You can't be like, if you don't give me like how a lot of apps these days say, if you don't give consent you can't proceed. You have to give them your geographic data, you have to give them your location. If you don't give your location, you can't proceed, and that's a conditional consent, right? Or if you give your like there are lots of times where we'll have to go on to see if they're also actually considering conditional consent to be like a consent which your iPhone these days takes. If you use iPhone, you will know they take consent that we will use your location only when the app is running, or when we're on the app. Now I don't know whether my app is running, if they mean when my app is running, when they are when it's in the background running or when I'm on it as well. So those kind of things we'll have to see how the Indian laws specifically. We know how it works in GDPR, we know how it works in COPA, California, but we don't know how it's going to work in India right now. With clear affirmative action, extremely clear with that as well. Consent shall signify an agreement to processing of personal data for specified purpose and be limited to such personal data as in necessary for such purpose. Right? Any part of consent that infringes these provisions of this act or rules shall be invalid. So very, very clear. Next is certain legitimate uses. This is again a section in the Act as well. And it goes on to say that data processing shall happen for specified purpose for which data was voluntarily given to the fiduciary. But and for the state, it goes on to say where where she has previously consented, either previously consented or such data is available in its digital form for any purpose of any legal issues or any purpose of executing of law, for any compliance with order and judgment of by a competent court, for medical emergencies, for medical treatments and health, or to ensure safety. So these are legitimate uses they are saying. Either it will be legitimate use for a private individual will be specifically for the purpose for which it was given, and then there are certain exceptions to that, right? What is the data fiduciary's obligations? They should be responsible for complying with this act. They should engage, appoint, use, or otherwise involve a data processor. They should implement appropriate technical and organizational measures similar to GDPR. They should protect personal data, extremely important. They shall intimate the board in case of any breach. So if there is any breach, the fiduciary has to intimate the board. Now, please be mindful that there is no specific timeline also given so far. It goes on to say that that timeline may be defined in the notification by the central government. Erase personal data if data principal withdraws consent, again, right to be forgotten, and publish contact information of a data protection officer. Similar to, I mean, data fiduciary is very similar to, the rights are very similar to what they are for GDPR as well. Now, like I said, for children, very specifically defines what are the do's and what are the don'ts for if you're collecting data for children. So it says that the data fiduciary shall obtain verifiable consent from the parent or lawful guardian. We've already discussed this. Not process data that is likely to cause detrimental effect on well-being of a child. Now, that is very difficult to define, right? What is detrimental effect? What I think is detrimental to the child, to interest of the child, you may not. So again, gives birth to a lot of gray areas. Not undertake tracking or behavioral monitoring of child. Now again, that is something almost all tech companies that have a huge amount of data are doing these days. We know that your social media platforms, whether it's an Instagram, whether it's a Facebook, that's how you get retargeted ads. That's how you are shown a lot of content, or that is how your suggested content as well. Your behavioral and your activity on the platform is always being tracked, and we accept those terms because we are told that it is to enhance our experience on the platform. But this very specifically says if it is a data of a child, you should not undertake tracking or behavioral monitoring of that child, right? Extremely, extremely specific. Not to do targeted advertising directed at children. Now again, something that edutech companies and companies which deal with games for children or other platforms like that will have to be very, very careful of, because this creates a very big gray area. It creates a very ambiguous situation where we don't know how this is going to be managed, because there are companies which are located abroad, there are companies which are working on the basis of on the jurisdiction, in other jurisdictions. There are companies which are um, not compliant a lot of times with the Indian laws. So how do you stop targeted, and a lot of times, I mean, because a platform will go ahead to say that even though we are collecting data of children, I'm going to add a line to my privacy policy or my terms and conditions to say that this cannot be and should not be used by children on their own without a presence of a guardian of a lawful guardian or a parent. Now, in that situation, what if there's a targeted advertising? Are they going to go down to define what targeted advertising is allowed for children? We don't know yet. Again, now what are the rights of data principals? Similar to the GDPR, again, I would say that they have data principals have the right to access information about personal data. They have the right to correct and erase personal data. They have the right to redress, to redress any grievances that are that they have the right to approach a company for grievance redressal and have it redressed. If not, then we showed you there is a full hierarchy of where they can approach if their grievances are not being redressed. And they have the right to nominate a legal heir. Now this is also very interesting because looks like the DPA is looking at treating data as an asset, because I can nominate an heir who can manage my data after I have left the planet, after I have passed away, or even in my in my life here. I can nominate an heir who can take care of my data, how it is to be handled, updated, deleted, etc., etc. So extremely interesting aspect of dealing with data privacy and data in general. Now, what are the duties of data principal? Data principal, as in you and I, very important to know, because this is what we have to do, and we have to ensure that we do it. We have to act in compliance with the act, of course. We have to ensure that we do not impersonate another person. That we're not representing ourselves to be another person. We're not misusing another person's data as our own. So guys, please don't register on a platform using someone else's mobile number and etc., etc., or display picture. A lot of times we see the lots of fake profiles being made. We should not be doing that. Not to suppress any material information, very important. Whatever material information you have, or whatever material information you want to communicate, you should not suppress it. Not to register false or frivolous grievances. Again, all of us know what that means. There's no point of registering false complaints against an organization just to maybe bother them, or just for whatever purpose we deem fit. Furnish authentic information, very important to furnish your own information. Again, similar to ensure not to impersonate another person. But yeah, that's those are the duties of a data principal. Now, since this is again a topic that has also been very, very highly debated and discussed, and was a very big concern the last time the bill was tabled in the parliament, is how are entities supposed to be processing data outside India. And I mean, a lot of people would be happy, or I'm not sure, maybe a little confused about this, on whether they're happy or not. But it just simply, the acts right now, as of right now, just goes on to simply say that the central government may restrict transfer of personal data by a data fiduciary outside India. Now it doesn't, and on the basis of territorial or jurisdictional limitations. So again, like the central government tomorrow can decide that we don't want to allow the data to go to Mars, and it does not go to Mars. As of right now, there is no such restriction, but through a notification, the government can decide, depending on the global relations, or India's aspect, or India's inclination towards a relation with a country. We can decide on whether an entity or a data fiduciary can transfer data from India to another country. So, like I said, the Data Protection Board of India, it has multiple members, but the main member is the chairperson. The chairperson is going to be appointed by the central government. Then there is a consent manager, and then there'll be other members. The board has very, very defined roles. I'm not going to go into the detail of that because it's not very relevant to us in this session today. But yeah, I mean, the board has a lot of obligations, duties, processes, etc., etc., that it has to follow. Now, I would want to take you guys towards the aspect of discussion specifically that we have, and this is the last discussion slide that we have right now. After which, we can also open the floor for more questions. Is what is the impact on information security professionals? Now, in information security professionals are essentially people who are going to be impacted by this law, primarily because it deals with data and information security. And they are basically I mean, aside from complying with the Act's protection principles, these professionals, I mean, data information security professionals, may also require to understand how all of these aspects work, and in order to make the entire experience and the entire process of an organization foolproof and compliant with the law, it's going to be very important to understand how the whole all these terms work. How does the flow of information work, how is information to be stored, information to be protected, information to be transferred, etc. um, One more important aspect of this act is that, um, does this act, one question that we get asked often is, does this act deal with data audit also? So while it does not deal with data audit overtly, it will definitely affect data audit, because it essentially has gone on to require large entities to appoint independent data auditors, which the act mentions, to carry out data audit and evaluate the compliance with the provisions of the bill. So it's going to perhaps, we're not sure yet, but perhaps tomorrow there'll be a notification from the central government wherein data protection auditors will be expected to give a report to the board, perhaps for each company which is dealing with a certain level of data, and uh, people, or maybe revenue basis, etc. It will also empower the Data Protection Authority to conduct audits and issue directions or penalties for non-compliance, and establish a framework for data quality, security, transparency, accountability, and consent. So, that is how the Data Protection Act will be important for a personnel to, an information security personnel to uh, kind of understand the legislation and see how it works at large. One point also that we haven't discussed today was around the penalties that have been defined for non-compliance. Like, there is a separate schedule that the act defines, which talks about, in case there is a breach of provision of this act of the DPDPA, what are the penalties? And there are some 7 or 8 instances which have been defined in the act, which also have a penalty defined, and the penalty, I must say, is pretty substantial. So yeah, I mean, that is a brief discussion on the act, on the provisions, and maybe we can now look at taking up some questions, and you know um, yes, Chirag.
Thank you, ma'am. We've had a number of questions from around 10 to 15 members who are watching this currently. So I'll take them
Okay,
up one by one.
sure.
First is by our own board member, Mr. Lalit Kumar. He's asking, how is this act going to impact the existing systems like core banking, core insurance systems, which were built without privacy in design feature?
Okay. So thank you so much, sir, for this question. Firstly, as the act goes on to say that, even it has actually, in fact, specifically mentioned that even for companies which are already dealing with data and have already considered or collected certain data from data principles belonging to India, they have to now, going forward, the day of implementation of this act, take consent from each of these data principles. That's the first aspect. Second aspect is, considering the industries that was mentioned right now. Like I said, the definition of personal data has been kept to be at a very in a very generic manner, and it does not specifically define sensitive data like the GDPR does. But because the personal data is covers everything in its ambit and scope, that is, which is why the all these companies also will fall under the ambit of protecting and ensuring that they collect and store data in the right manner. One more important aspect would be that, this act does not define very clearly about what happens to transfer of data. Like, for example, when data is being transferred from one entity to another. So that is again, it only talks about transfer of data outside India, outside the territory of India. So yeah, I hope that answers my the question that was posed.
Thank you. Our next question is from Mr. Arbaz Khan. He's asking, does this act cover personal information of foreigners as well?
It actually deals with personal information of people who are resident in India and citizens of India. So if there is a foreigner who is resident in India, yes, if they are living in India for the period that they're living in India, it will also consider them.
Thank you. We've had a follow question from Mr. Lalit Kumar. He's asking, is there any time frame that would be given to comply with the requirements of this act? I think he's
No, no,
referring to
there
the
is.
banking insurance industries.
Yes, I understand that. No, there is no time frame that has been given that that you have to comply within certain time frame. I think primarily what they are expecting is that you intimate your users that from now going forward, this is how we'll be dealing with your data, and collect consent from those individuals who are logging onto your platform now going forward. There is no timeline defined in the act so far.
Next question is from Ms. Virali Mehta. She's asking, what do you suggest to HR companies which have already collected static personal data of potential recruits before this act came into effect? Do they have to remove such data from their servers and storage?
So no, they don't have to remove. Again, I think similar question to the last. I mean, similar answer to the last question, that they don't have to remove any data because the data has been collected, and I believe most of the companies these days who are even semi-compliant or have policies in place have been taking consent in one way or the other. So essentially, what we have to do now is to update that consent taking process, take consent in a very specific manner from users who are still interacting with your platform. If there are any static data that you have on the platform which have no interaction or little interaction, users which have little interaction with you, you can perhaps keep them till you have a legitimate purpose. Now, the duration of which an entity can keep data in its store has been limitedly defined, or let's say unlimitedly defined, to till when they have legitimate use and specified purpose to keep that data. So there is no 1 year, 5 years, 10 years, 20 years definition at all. So in case of an HR company, if there is a specific set of or requirement or purpose of that data that you need to keep, you can store it in your organization's database.
Thank you. Shuvendu sir would like to ask a question. Sir,
Yes.
Yeah. Uh, one practical situation that I had faced. I would like to get your views on this particular case that happened with me. See, one of the foreign companies, they had stored some data uh, of mine in their server,
Mhm.
and this data was hacked, and
Okay.
some outside hackers, whoever has done it, uh, they started utilizing this data to initiate process of debiting my card information, or even they had raised invoices on me and
Hmm.
asking me for payments, and
Okay.
this went on and on. Now, here my question would be that do I get a remedy in the Indian laws, or I have to raise something in GDPR? It was in Europe, so I have to raise a issue on GDPR. What is your take on this?
Okay, thank you for the question, sir. So, firstly, I think this issue may be, not only a data privacy but also a cybercrime issue in totality, because this is not simply a data privacy concern. If it was a data privacy concern, till yesterday maybe we would have had to approach the GDPR. But however, GDPR also in its ambit defines that it primarily governs European Union residents, and as of today, when we have the act in place, unfortunately the act is also still silent. So maybe if you came to us as as lawyers to help you out with the situation, we would have recommended that we proceed with this complaint from a cybercrime perspective, wherein there has been a breach of security, not only data, not only information, but there's a major lapse in breach of security that has happened, wherein there has been hacking. The moment aspects like hacking or impersonation or anything related to cyber issues are involved, it becomes a cybercrime concern as well. So perhaps from that perspective, we could have taken an action from India by filing a complaint against those the perpetrators and trying to get a information from there, because that is the jurisdictional issue that European Union generally said protecting its residents and citizens. However, there have been situations or considerations where as a user, if you're transacting with a European Union based organization, you can also approach the their grievance officer or their data protection officer and take that up with them as a complaint.
But here, don't you think that for those organizations who are keeping data, personal data of people, they can just get away saying that this was a hacking done on our system, and they have not sufficiently protected themselves with all the kinds of protections that are available today. So this kind of organization can get away simply by saying that this was a cyber crime and we have nothing to do with it. So don't you think this will be a very a situation where many people can escape, many organization can escape without taking the responsibility of the data?
No, absolutely. I completely agree with that. And, which is why all the laws across the world keep resonating the fact that, as a entity that collects information, that collects data, you have to have the best security, measures taken as possible. And, of course, if there is any lapse there, they are accountable for it, especially under the GDPR. They are held accountable for it massively if there is a lapse at the end of the entity or organization. However, having said that, hacking again is not something that can be taken as a defense counteractively. Like, if my organization is hacked, before the complainant comes and complains that XYZ happened to me, I have to perhaps have that audit and risk check done to ensure that I'm aware of that hacking, and also proactively file a complaint. Otherwise, it depends on the type of business that it is, but in a lot of situations, merely because a system is hacked does not mean that till that can be traced. I mean, these days cybercrime authorities have also become extremely proficient with their softwares and their technologies, where they can actually see whether there was a hacking or if there was just simply a negligent action and hacking, but these people could have been more careful of their protective systems as well. So it's become like an ecosystem, and I guess in a space where there is technology, these issues will always persist, security issues, hacking possibilities, etc. So I think organizations are being made mindful of it. Organizations have to be liable to ensure that they are protecting the information that they store to the best of their abilities.
Thank you so much, Vasundhara, for your response on this question. Over back to
Thanks.
you, Chirag. Yeah.
Thank you, sir. The next couple of questions are from Mr. Somdev Bhattacharya. He's asking whether this new act will create issues for those organizations that are doing data analytics work in the form of big data, AI, ML, deep learning related work.
So not necessarily, as long as the organizations are ensuring that the source of the data that they're dealing with, because I understand that all of these industries that were mentioned right now deal with heavy amount of data. They deal with a massive amount of data, in fact, and that is what helps them create better processes and systems. So it may not necessarily create problems, but it will definitely need more structuring, more processes in place for these organizations to be able to comply with the said act. And I feel like it is also important for us to understand that right now what happens is a lot of times data is just shared very arbitrarily and very carelessly I would like to say. So in that case, I think these companies also need to be very careful of how they're procuring data, what are they doing with that, how they're storing that data, etc. And then once it's processed data, but as we've seen, since the law does not define pseudonymized data or aggregate data in any manner and doesn't cover it in its ambit, Under the DPDA, at least, we are out of the ambit once it becomes pseudonymized or is not personal or personally identifiable anymore. So I don't think that should be a problem.
Thank you. Another question from Mr. Somdev is whether the qualification or experience for joining the DPO, the auditor or other role is defined or not. So I think he's basically
No.
asking the credentials that, okay,
No, unfortunately, I understand that. Thank you, Chirag. I don't, unfortunately, there is no definition of the credentials that are needed. It talks about generic things like, they should have the information of technology, they should have the information on how, digital world works, they should know about, they should be, they should have integrity, they should not be biased, etc., etc. However, there is one aspect which I found to be very interesting, which is about the board and its members, the DPB, the Data Protection Board and its members, that any person who's a member of the DPB will not be able to join any other employment, the chairperson or the consent manager, for a period of 1 year from the termination of their role as a chairperson of the DPP. So I found that to be very interesting. Apart from that, no, unfortunately, there isn't a lot of very detailed, criteria is defined for who can be a part of the DPP or the data protection officer. I think it's a industry standard where they would want someone who understands technology and how data works, and how the digital world works, etc.
got it. The next question is from Mr. Jayanto. He's asking the quantum of penalties regarding the failure to protect the data by the companies.
Okay, so what I will do is I will just like actually take everybody, the audience, through the schedule that talks about the penalties, because there is no there, like I said, there are 7 types of breaches that are defined, and then there are 7 types of penalties that is defined. So I'll just take you guys through it. It basically says, if there is a breach in observing obligation of data fiduciary to take reasonable security safeguards, like sir was mentioning earlier, to prevent personal data breach under subsection 5 of section 8, it may extend to 250 crore rupees. So that is the extent of liability that can be brought on to a data fiduciary in case they are unable to take reasonable security measures, and that shows that there is a lapse or loss of data because of that. In case there is a breach in observing the obligation to give the board or affected data principal notice of a personal data breach, then the liability or the penalty may extend to 200 crore rupees. So, similar. If there is a breach in observation of additional obligations in relation to children that we just discussed, if someone is breaching that aspect of children's rights, the liability may extend to 200 crore rupees. So, this is the aggregate liability that a company, of course, it depends on what kind of a company it is, what is the quantum of data, what is the size of the revenue of the company, etc. But this is the top limit that has been defined. Breach and observance of additional obligations of significant data fiduciary that we discussed may extend to 150 crore rupees. Breach and observance of duties under Section 15, which is the duties of the fiduciary, shall extend to 10,000 rupees. It again will depend on the type of case. Breach of any term of voluntary undertakings accepted by the board will be up to the extent applicable for breach in respect of which the proceedings under Section 8 were instituted. So this is about talking about the board. And breach of any other provisions of this act or rules made here under, it may extend to 50 crore rupees. So that is the essentially extent of penalties that they have defined.
I believe that the quantum of penalty in this particular act is the highest in amongst all of the Indian acts, at least.
Absolutely, absolutely. I think it's pretty much very much in line with the GDPR as well.
Right.
GDPR also has massive penalties for its non-compliance, and so does this act. I mean, till now, Indian acts have penalties like 10,000 rupees and 5,000 rupees. So this is definitely
Quite a
a
huge jump
very big
over
jump.
there.
Absolutely, absolutely.
Right. Moving forward, the next question is from Mr. Shivraj Jalur. He's asking, how does the privacy bill different from other jurisdictions? I think he
So
might be referring to GDPR or other acts.
Absolutely. So, like I mentioned at the very beginning of the discussion, also that this bill is, I wouldn't say it's very different, apart from the fact that it gives a lot of, it gives does give certain amount of power to the central government, and there are lots of things which have been kept to be decided in the future by and via notifications in the future by the government. Apart from that, when we compare it with the COPA, which is the California Consumer Protection Act, and the GDPR, because and then there is the China law and lots of other data privacy acts that we work with. The basic principles, I would say, are similar. This is a less extensive act for sure. It's briefer, but it does take in consideration the main aspects, which is consent, that user needs to give consent. User should be told what, and informed well in advance before taking consent. And apart from that, that anybody who's collecting this data should be responsible and be aware of what it is that they're doing when they're collecting this data and how they're supposed to be dealing with it. But all in all, this is a less detailed act than the other ones, because the other acts go on to define a lot more terms and a lot more situations. And maybe this is a better way of creating a legislature for now, because all of us know that the tech world is extremely dynamic. It's changing it's progressing very, very quickly. So it gets very difficult to define or over define things as well, that also is a negative aspect in a lot of situations. So I would say it's a fairly balanced act. It's not very ambiguous, but also not very, very specific or detailed that it becomes redundant in the next 2 or 3 years, with maybe some AI changes, or maybe some other virtual world related changes. So I would say it's a fair balance. Yeah.
Right. Adding on to this, I believe that the previous drafts they were a lot more detailed.
Yeah.
So bringing those was a bigger task actually. So initially they came out with this draft, and obviously whenever a new law comes into picture, there it obviously goes through some changes. So maybe that is something for
Absolutely.
that time will tell later down.
Absolutely. Absolutely.
Okay. Moving forward, Mr. Shivraj has a couple of other questions. He's asking, do all government bodies and agencies collecting civilians' personal data, they fall under the ambit of the data privacy bill or not?
So government bodies, yes, because it essentially defines the state as well. What it goes on to do is that it says that when we define person, we are also defining the state. And when we define the state, while the state has a the meaning of anything that is government owned or government run, it doesn't specifically define PSUs or semi government bodies or entities which are primarily government owned. But the moment it's a company or an organization, yes. So there is no clear definition or exclusion of a government entity in that sense.
Got it. Only they have the power to exempt any of the department from this act, right?
Yes. Yes.
So, a final question from him is penalties imposed by the board, can they be challenged through legal institutions like the courts?
So, okay, one more thing that we can, perhaps would be important to mention here is that the Data Privacy Act has very specifically said that all the processes in under the Act, the DPDPA, is going to be undertaken as a civil action. It is not a criminal action. There are no criminal penalties. There's no incarceration or imprisonment. There is only monetary penalty, which is a civil remedy, as all of us know. So while the act does go on to say that you cannot, like for example, I want to go to the board. I go and complain to the board with an issue. I cannot at the same time go to a high court or a civil court and try and of appropriate jurisdiction and try and get an injunction, or a stay on something that a company has done. But however, I think after we have reached the appellate tribunal, which is the TDSAT, we can maybe then appeal against that in the normal course of action, which will be at the High Court. So I think in that process we can, but we can't go and take a stay, and that has been very specifically, surprisingly, but very specifically mentioned in the legislation also, that you have to first go through the process of that has been defined in hierarchy, that has been defined in this. But these things are also things that have been defined in other acts, and they kind of evolve over time through precedents of courts. where there may be a situation where the court can, tomorrow, after this, all the entire process has happened, they can maybe come up with an exception and say that if this happens, you can come to us and we'll give you a stay, over a period of maybe 5 years, 10 years. That is a possibility. So I feel like, and when I see, look at this act, I feel like it's going to evolve tremendously over a period of time, with more legislation and more court action and judicial pronouncements on it, and then it will become a lot more comprehensive than it is right now.
Got it. So we have another legal question from Mr. Umesh Kumar Chaturvedi. He's asking what will happen if the grievance officer rejects the person's complaint at the first instance only and does not take it up any further.
So then we can go to the board, which is why the consent manager and the board has been placed. If the grievance officer is not, it doesn't matter whether they've heard you over a period of multiple rounds, or if they've heard you once. You can always go into appeal to the board. Once the board also gives you an order, positive or negative, heard you or not heard you, you can go to the TD sat, and if there also there's nothing happening, then you can go to the court as well. So that is those options are available.
Got it. Mr. Dinesh Shaw is asking if there's any specific criteria to select the auditor, like a certain impaneled auditor or any CISA auditor can perform audits. Whether any exception for startups are there. I believe you've already answered that. So when you had mentioned that no specific qualification is mentioned thus far right now. So we'll move
Yes,
further.
there's no
Mr.
specific
Sanjeev,
requirements.
right. Mr. Sanjeev Agarwal is asking whether this act applies to firms of all sizes and will it regulate firms who unofficially collect data from other means as well, like spam calls or sell data as well.
So it does apply to all types of organizations. It does not kind of make distinguish, or it does not differentiate between the revenue or size or number of people in an organization. So applies through to everybody, all private organizations. Whether it will apply to companies collecting data unofficially, yes. If those companies are being brought to question, then yes, like essentially no. And as far as this act is concerned, it wants to create a world in India where nobody is collecting data unofficially, right? Essentially, right, it wants to create a ecosystem where anybody who's collecting data is doing it with consent, with a lawful purpose, for legitimate use. That's it. So anybody else who's doing that is in contravention of this act, and hence will be liable for for violation of whatever many ways that they're violating this law in, essentially.
Okay. So we have another legal question. It says that what happens when if the Data Protection Act is in direct conflict with some other act, like for example the Banking Regulation Act. They specifically have their members, which are the banks, to store their data within local territory of India. So in case if there's some conflict with respect to the Data Protection Act, which one will take precedence?
So in that case, which is why I think they haven't come up with a definition of whether you can store, whether you have to store data locally or move it abroad. And I think maybe when the central government does come up with a notification, they will perhaps and hopefully take care of that. But with respect to which act will have more precedential value, it is mostly going to be the act which deals with data. So it may be the Data Privacy Act, but I'm looking at organizations maybe challenging that aspect of banking regulatory organizations, and banks generally also perhaps challenging that aspect of the act, where they would want to know whether this is whether they which one holds precedent. Because as far as law is concerned, generally when there is a conflict of two laws, then the law which talks about that data subject more specifically or more categorically is the law that is given precedential value to. Or then it is a dispute that is to be decided before court, and then the court can decide on what is to be considered as precedential value.
So maybe this will create a lot of litigations in the upcoming times.
Yeah, yeah. No, I mean, I'm sure there has been years now. I think this law has all of us accept that it has come a little bit late in the day, because technology companies have been operational in the country and in the world for years now, decades now. So there is a lot of data that is already out there without consent, without legitimate use, without any specified purpose. So there will be a lot of issues that will crop up, but better late than never. So now we'll start and hopefully catch up with the rest of the world.
Great. The final question so far, this is from Mr. Ansh. He's asking, how is this law going to impact MNCs which have development offices in India?
So, I think essentially same similar concept applies. Whichever data you're collecting in India, you keep in India, and unless and until there is a specific. So these are the things like we don't know when the specific notification from the government is going to come, and what are the countries that it restricts, from sharing of data. So for now, because it is a negative right that's given, because it says that until unless the government, central government, does not restrict, you can transfer data, we can continue to process and proceed in the way that we've been working essentially.
Got it. Mr. Sanjeev Agarwal has a follow-up question. He's asking, nowadays we get a number of fraud and spam calls from unknown numbers and persons selling something or another. Would this act arrest such a situation?
So I think this again is more of a cyber issue than a data privacy issue per se, because the data privacy, because see, essentially what it's doing is, you can, for this issue you can go. There are two aspects, right? Like if you come to me as a lawyer for this query, there are two ways to deal with this. One is, do we take an action against the company for having access to my data unlawfully without my consent? That would depend on the company. The second is, do we take an action on the person who's made this call to me, as a person who has, kind of breached my privacy by contacting me out of without my consent. So those are two, aspects that we can look at. If you're going through the data privacy as route, it will be a civil action. You'll have to go to court, file a suit, try and find out and allege, or before that you'll have to go contact the grievance officer. Grievance officer may give you an explanation of where did you get your data from, when did you consent to that data, etc., etc. If they're able to give that to you, that information to you, and if they're able to procure that from the company and give you that information, that's great, works. If they're not, then they may give you a generic reply and say that there is we have your data owing to XYZ situations, where you may go to the board then, and the board will then ascertain on whether your data was unlawfully procured and used by the company. And yeah, I mean, and depending on that, you can take an action. If the board's finding is that your data was procured from XYZ situations without taking your consent, then the board will hold them liable and perhaps put a penalty on them. And if all of this doesn't work, then you can go and file a criminal complaint also, for cyber issue, essentially cyber related crime.
So, Mr. Sanjeev is asking regarding this only, that in this particular case, the personal data, which is the mobile number, is used. So everything in this aspect will be parked into cyber security breaches jurisdiction. So is there any other solution?
The solution is that if your contact number is used, it's still your personal data, right? So it can be, it will also fall under the ambit of DPA, where you have the solution of going to the grievance officer and then to the board, the data protection board, with your complaint.
Got it. I think that's all for the questions that we have right now. So
Okay.
let's proceed towards the vote of thanks. Shubhendu sir.
Uh, Thank you so much, Vasundhara, for a wonderful presentation, for a very, very clear understanding of the new law that has come in, and for taking the trouble of answering to all the questions and queries that have come up from the audience. Uh, Indeed, ISACA Kolkata chapter is very thankful for you, for sparing your professional time and sharing your knowledge. I think it has been a very good value additions to us, and definitely we look forward to you participating in future conferences of our chapter. Thank you so much.
Thank you so much, sir. It's been a pleasure, and thank you so much to Chirag as well for helping me, set up with this and for conducting the session so well. And like I said, it's a topic which is important for each and every one of us, and we all should be careful and wary, especially in today's world where our data is everywhere, and it is also considered to be a fundamental right now. So it's good to know that topic of fundamental right, because other fundamental rights most Indians don't know about. So it's great to know that it's actually affecting people, it's actually affecting everybody, and they are aware of it as well. So yeah, I think that's also a great development. So it's been a pleasure.
Thank you.
Thank
Thank you
you.
all.
Thank
Thank
you.
you. Thank you, Chirag. Thank you.
Thank you, sir.
Thank you.